While the Ozturk ROA implies a connection between Ozturk and now banned Tufts student for justice in Palestine, the report presents no evidence other than Ozturk's membership in Graduate Students for Palestine, which supported proposals to the Tufts, which were also supported by TJSP, nor has DHS ICE HSI shown any evidence that Ozturk was involved in any of the activities which resulted in TSPI being banned. Jesus Christ. If you want to see more content like this, make sure you subscribe to the YouTube channel and follow me on Instagram and TikTok at Rinyald. And if you disagree with anything in the video, make sure you join the Discord and we can have a chat sometime. Trump has long pushed to punish flag desecration. And the latest post sharpens his law and order message as the government shutdown continues. What? You literally say up here that it's protected speech, Fox. Supreme Court rulings Texas v. Johnson and United States v. Eichmann held that flag burning is protected speech. And then he says Trump, the latest post sharpens his law and order message. No? Sharpens his fuck the First Amendment message. I'm sorry. President Trump will not allow the American flag, a special symbol of our country's greatness, to be used as a tool to incite violence and riots that jeopardize the safety of everyday Americans. President Trump will always protect the First Amendment, LOL, while simultaneously implementing common sense. Oh my God. Thank God we could just hand wave away any criticism of anything ever by saying it's common sense. Oh shit, I forgot it was common sense. Because famously, if something is common sense, you need to be told it. If anybody ever asks you anything and someone says it's common sense, just ignore them. Because if it was common sense, then I wouldn't be asking you about it. Whatever. Common sense is just, I don't know. Fuck you. I don't want to answer that. That's the translation. Another disgusting attack on our First Amendment from the president. It's really, really, really cool. Really cool. Really cool. What is this? Trump has pardons and tanks. What do you have? Dear Mr. and Mrs. Anonymous, alone I have nothing but my sense of duty. Together, we the people of the United States, you and me, have our magnificent Constitution. Here's how that works in this specific case. What does that mean? We're not reading this whole order, by the way. We're just reading part of it. The landmark ruling, a federal court today ruled that the Trump administration's policy of arresting, detaining, and deporting non-citizen students the AA violates the First Amendment. The AAUP, the Middle Eastern Studies Association, and several AAUP chapters brought the suit with the Knight First Amendment Institute at Columbia University, seeking to block the Trump administration from carrying out large-scale arrests, detentions, and deportations of non-students and faculty members, Jesus, for ideological reasons. A 2-week trial in July was the first major trial of Trump's second term. I don't know about that. And included testimony of 15 witnesses, forcing the disclosure of a wealth of new details about the policy and its devastating effects on campuses nationwide. Hi there, Mr. Phoenix Sigma Man Alpha Riz. Good to see you. In today's ruling, Judge William G. Young wrote, "This case is perhaps the most important case ever to fall within the jurisdiction of this district court. It squarely presents the issue whether non-citizens lawfully present here in the United States actually have the same free speech rights as the rest of us. The court answers this constitutional question unequivocally, yes, they do." What are you reading? This is the court ruling about Trump targeting pro-Palestinian people for their speech for deportations. The First Amendment does not draw Trump's invidious distinction, and it is not found in our history or jurisprudence. That's the First Amendment. Ozturd. That's this. Another divider. You can't see a lot of my notes, but trust I am taking really, really good notes right now that are all available in the Discord. AAUP v. Rubio. I always put an extra I in. Sounds lovely to read about. Maybe if you're a Sigma, you'll learn how to fiend. Maybe. Don't get your hopes up, though. On January 20th, 2025, the first day of President Trump's second term in office, he promulgated 26 executive orders, ostensibly issued to reverse conduct of his predecessor, barred federal officials from any conduct that would unconstitutionally abridge the free speech of any American. President Trump makes clear that, in his view, the First Amendment's protection of freedom of speech applies to American citizens alone, and to an unconstitutionally narrow view of citizenship at that. This case, perhaps the most important case to ever fall within the jurisdiction. Okay, yeah, so we already read that. With this Constitution ruling firmly, undergirding, its approach, a court here held a full hearing, a 9-day bench trial on the issues whether the rights of these plaintiffs to constitutional freedom of speech have been unconstitutionally chilled by deliberate conduct of any or all of the public official defendants. The court heard 15 witnesses and admitted 250 exhibits consisting of documents, photographs, and video clips. Is that funny? Some court rulings are just overly verbose for no reason. That's it. Having carefully considered the entirety of the record, is this all real, like real things? Yes, this is all real. Having carefully considered the entirety of the record, this court finds by clear and convincing evidence that the Secretary of Homeland Security, Kristi Noem, and the Secretary of State, Marco Rubio, together with subordinate officials and agents of them, deliberately and with purposeful forethought, did so concert their actions and those of their two departments intentionally to chill the rights of freedom of speech and purposefully and peacefully to assemble of the non-citizen plaintiff members of the plaintiff associations. What remains after issuing this opinion is to consider, if anything, what may be done to remedy these constitutional violations. Actually, there is but little dispute over the facts, but here they are. Okay. AAUP is a nonprofit membership association and labor union of faculty, graduate students, and other academic professionals with chapters at universities across the country. As AAUP's general counsel testified, AAUP is one of the nation's oldest professional organizations that represents faculty and graduate student workers at universities and colleges in the United States. AAUP's goal is to define, protect academic freedom and shared governance principles. Central to its mission since 1915 is to protect its members' right to engage extramural speech. That is, speech that was made purely as a citizen, not as a researcher or a scholar. AAUP is a national organization that also has chapters at other universities, which includes advocacy and collective bargaining. Can you go to India's ones? So I don't think I can. Middle East is the largest international organization that focuses on Middle Eastern studies. According to its website, its mission is to foster the study of Middle East, to promote high standards of scholarship and teaching, to encourage public understanding of the region and its people through programs, publications, and services. Oh, the Indiana's ones. I live in Indiana. I don't know what you're asking me. Congress passed the INA. As set forth below, Congress delegated to the Secretary of State significant authority to exclude or classify a deportable non-citizen from the United States and to revoke visas. For non-citizens attempting to gain entry into the United States, a non-citizen whose entry or proposed activities in the United States the Secretary of State has reasonable ground to believe would have potentially serious adverse foreign policy consequences for the United States is inadmissible. Congress has clarified that a non-citizen is generally not excludable or subject to the restrictions or conditions or on entry of the United States on account of the citizen's past, current, or expected belief statements or associations, if such belief statements or associations would be lawful within the country, within the United States, unless the Secretary of State personally determines that the non-citizen's admission would compromise a compelling United States foreign policy interest. Okay. For non-citizens already present in the United States, I apologize, you're all good. A non-citizen whose presence or activities in the United States the Secretary of State has reasonable ground to believe would have potentially serious adverse foreign policy consequences in the United States is deportable. The INA incorporates the same exemption or exception, that is, while a non-citizen is present in the United States, is generally not deportable on account of non-citizens' past, current, or expected beliefs, statements, or association is such, that non-citizens may be removed if the Secretary of State personally determines that the non-citizen's admission, blah, blah, blah. Essentially, the INA and the INA... Okay, exceptions place profound but narrow exclusion and deportability classifications powers solely in the Secretary of State. With respect to a non-citizen's visa holder pursuant to 8 U.S.C. 1201, after the issuance of a visa or other documentation to any alien, the consular office or the Secretary of State may at any time, in his discretion, revoke such visa or documentation. Discretion is guided by Chapter 9 of the Foreign Affairs Manual. You look tired? I'm a little tired. Okay. The INA does not contain a provision with respect to revocation of visas based on past, current, expected beliefs. Okay. The Department of State is charged with, among other things, determining whether and on what condition non-citizens are admitted to and permitted to retain status and remain in the United States. The Department of State is headed by Defendant Marco Rubio, a presidential appointed and Senate-confirmed cabinet member. As pertinent to this action, Senior Bureau Official, Bureau of Consular Affairs John Armstrong is the highest-ranking counselor at the Department of State's Bureau of Consular Affairs, holding that position since February 27, 2025. The Department of Homeland Security is responsible for, among other things, the protection of the United States from internal threats, just as the Department of Defense protects the nation from external threats. The Department of Homeland Security is headed by the defendant, Kristi Noem, a presidential appointed, oversees Immigration and Customs Enforcement, which oversees the Department of Homeland Security investigations. This song is loud as fuck. Get that trumpet out of here. What are we doing? Okay, Assistant Director of National Security Division at ICE, Andrew Watson, is the senior most ranking official at National Security Division. Assistant Peter Hatch is the most senior official at the Office of Intelligence, which operates under the umbrella of HSI. The Office of Intelligence supports investigations by producing research, analysis, traditionally on criminal networks, criminal conspiracies, those engaged in criminal conduct. A.D. Hatch oversees a compilation of intelligence reports known as reports of analysis. ROAs are compiled by approximately 1,000 analysts who conduct investigations and review a variety of non-public and publicly available sources, otherwise known as open source. July 10th, 2025, to inform, among other things, on potential violations of the INA and criminal laws to DHS and other agencies. Hatch reviews approximately 1,000 ROAs per year, and his office produces about 25,000 to 30,000 ROAs in total in any given year. With respect to the student protest, Hatch reviewed approximately 100 ROAs. There are approximately 100 to 200 ROAs total generated with respect to student protests. While there is an internal review process, A.D. Hatch does not sign off on ROAs. Since March 2025, the process of initiating the removal of a non-citizen under the INA is rather straightforward. Under the process at issue in this action, HSI's issues an ROA, which is then presented to the National Security Division. Upon review, if A.D. Watson and his team determines that it is appropriate, he sends a letter to the Department of State, sometimes referred to as a DHS referral letter. That DHS referral letter is reviewed and a recommendation is made to CBO Armstrong if it concerns revocation of a visa under the INA. If it concerns a lawful permanent resident or foreign policy reason, a recommendation is made to Secretary Rubio, so he may statutorily require personal determination. Okay, this is kind of... Okay, so an ROA. Sorry. It's then presented to the National Security Division. Upon review, if A.D. Watson serves as if the assistant director at the National Security Division of ICE and his team determines that it is appropriate, he sends a letter to the Department of State. Sometimes referred to as a DHS referral letter. That DHS referral letter is reviewed. The recommendation is made directly to Armstrong if it concerns revocation of visa under the INA. Or if it concerns a lawful permanent resident or for a policy reason, a recommendation is made by Armstrong. to Secretary Rubio, so then he makes his statutorily required policy determination as to whether the non-citizen ought be removed under the INA. If the recommendation is approved, CBO Armstrong or Secretary Rubio informs NOM of the change of status of the non-citizen. Okay. Is it frustrating debating Trump supporters who don't acknowledge facts? Yes, it is incredibly frustrating. Okay. That's helpful. On September, former implements written policy banning consideration of exercise of the First Amendment rights and enforcement of the INA. Okay. On September 30th, 2021, Secretary of Homeland Security Mayorkas issued a memorandum stating in pertinent part, we must exercise our discretionary authority in a way that protects civil rights and civil liberties. The integrity of our work and our department depend on it. A non-citizen's race, religion, gender, sexual orientation, or gender identity, national origin, or political association shall never be factors in determining or deciding to take enforcement action. A non-citizen's exercise of their First Amendment rights also should never be a factor in deciding to take enforcement action. We must ensure that enforcement actions are not discriminatory and do not lead to inequitable outcomes. October 7th. Yep. Have you heard of Roy Cohen? No. We can look him up though. He does sound familiar though. McCarthy. What about him? Mysterious U.S. lawyer who helped Donald Trump rise to Oh, I have heard about this guy. Yeah, I just haven't done a lot of reading into him. Yeah, he's the... didn't The Apprentice make, like... Wasn't the whole point of that movie to show that this guy basically like, corrupted Donald Trump and taught him how to be a scumbag? It's Trump's lawyer and then in the 80s. Yeah, he's like the Rudy Giuliani or the Stephen Miller in modern terms, right? Upon President Trump's inauguration for his second term, he issued an executive order entitled Protecting the United States from Foreign Terrorists and Other National Security and Public Threats. Okay, we're on page 15. AAUP versus Rubio. Claimed to be smart as Trump, or were you a billionaire at age 8? No, guess I wasn't. Okay, we were on page 15. Yeah, okay. The president declared that it is the policy of the United States to protect its citizens from aliens who intend to commit terrorist attacks, threaten our national security, espouse hateful ideology, or otherwise exploit the immigration laws for malevolent purposes. That executive order further states that the United States must ensure that admitted aliens and aliens otherwise already present in the United States do not bear hostile attitudes towards its citizen, culture, government, or founding principles. That's only the president's job. And do not advocate for aid or support designated terrorist organizations and other threats to our national security. That's a job for the president, motherfucker. I forgot to cite the page number. Page 16. So if they support J6, shouldn't be allowed. True. Page 12. On January 29th, issued an executive order, additional measures to combat anti-Semitism. The president declared in the executive order that it shall be the policy of the United States to combat anti-Semitism vigorously, using all available and appropriate legal tools. Never forget that this is the legal, by the way, addendum. To prosecute, remove, or otherwise hold accountable perpetrators of unlawful anti-Semitic harassment and violence. Ordered that within 60 days, the head of each executive department or agency submit a report to the president identifying all civil and criminal authorities or actions under the jurisdiction of that agency. Oh, you know that one guy from TikTok the other day who doesn't think immigrants have free speech rights? You should ask him sometime if it would be legal to pass a law that says immigrants must praise the Democrat Party on social media for 4 hours a day. That would be based. While compelling speech is different than prohibiting speech, right? So, I like your analogy a lot, where it's like, can you pass a law saying that immigrants aren't allowed to speak? I think that's a really good analogy. Beyond those already implemented that might be used to curb anti-Semitism, containing an inventory and analysis of all pending administrative complaints as of the date of the report. Additionally, the president ordered that the Secretary of State, Secretary of Homeland Security, in consultation with each other, shall include in their report recommendations for familiarizing institutions of higher education with the grounds for inadmissibility, so that institutions may monitor and report activities by alien students and staff relevant to the grounds, to those grounds, and for ensuring that such reports about aliens lead to an appropriate, consistent with applicable law, LOL, to investigations if warranted action. Okay. Issued a fact sheet explaining that the Department of Justice would take immediate action to, among other things, investigate and punish anti-Jewish racism in the leftist, anti-American colleges and universities. He also made the following statement: to all resident aliens who joined the pro-jihadist protests, we put you on notice. Come 2025, we will find you and we will deport you. I will also quickly cancel the student visas of all Hamas sympathizers on college campuses, which have been infested with radicalism like never before. Can I find this fact sheet? No, our free speech rights also give us protection from being compelled. Yeah, but I mean, it is different though. It feels like it's not as analogous. When it feels like you could probably get the same concession out of more directly analogous example. So this is citation 3. Page 18 and citation 4. Okay. The Department of Justice forms a federal government task force to combat anti-Semitism. February 3rd, 2025, the Department of Justice announced the creation of the task force to combat anti-Semitism. Coordinated through its Civil Rights Division, task force's first priority will be to root out anti-Semitic harassment in classes in schools and college campuses. Secretary Rubio issued a diplomatic cable entitled Catch and Revoke the National Security Through Timely Processing of Student Systems Messages. That cable implements executive order explaining in its summary that because the Department of Justice is directed to maximum screening and vetting through the visa process, counselor must use the whole of government law enforcement systems to vigilantly monitor the activity of aliens, whether they're inside the United States or not. Jesus. Furthermore, if a consular officer catches an alien misusing a visa, officers should generally revoke it. Catch and revoke cable at 1. The cable anticipates domestic consumption, providing requests for revocation of visas where the individual in the United States must be sent to the revocation team. Armstrong testifies that the catch and revoke cable, known as an all back, and sent over 200 diplomatic posts abroad. According to Armstrong, the catch and revoke cable did not provide new legal authority for revoking visas, but rather relied on existing legal authority. Indeed, according to Armstrong, the catch and revoke cable increased vigilance of using this authority. The Department of State also performed partial review of its section. Okay. It's apparently successful, as a cable was later updated in May 2025 with guidance that relayed the doubling of visa revocations and a 150% increase in visa revocations over the same time period. Held multiple meetings with agencies to align. Although the council is not a secret, the public officials claim privilege as to its membership. And of course, much of what it does is necessarily concealed from the public, at least with respect to certain members. Steph Stephen Miller is also at the Homeland Security. Throughout March 2025, the Homeland Security Council had held interagency meetings to discuss, among other things, student visa relocations. These meetings included DHS, the State Department, the White House, the Homeland Security Council, Deputy Chief of Staff Stephen Miller, at times his deputy Andrew Adam. Oh my God, Leeson. Okay, approximately 12 to 20 meetings took place, mostly during March 2025. For the content of the communications, particularly from Staff Miller, public officials assert the presidential communications privilege. For purpose of the action, the limited content of the communication disclosed from Miller is unnecessary, and therefore the court did not need to rule on the assertions of privilege. The court nevertheless infers from the timing and number of those meetings that weekly meetings logistically intended to implement the administration policy with some respect to the executive orders, that the White House did not provide any guidance that contradicted the public officials' interpretation of the executive order, and that their actions related thereto as set forth below. To be sure, there is no evidence in the record that the president had any participation in other than executive orders and public statements attributed to him. Turn the music down. Turn your fucking mom down. Yeah, fucker. No, okay. Man, worst part about Trump's clear cognitive decline is Stephen Miller and the Nazi deep state will get more power. Yeah. In early March, Hatch attended a meeting with HSI senior leadership. The Office of Intelligence focused on non-citizens being charged. To look at protesters, to develop reports of analysis on the protesters, specifically looking for violations of U.S. laws, including and specific to immigration and customs laws. Speaking in general terms, it was anything that may relate to national security or public safety issues. Things like, were any of the protesters violent or inciting violence? I think that's a clear and obvious one. Were any of them supporting terrorist organizations? Were any of them involved in obstruction, like blocking normal citizens from going about their business? And would use of normal report analysis process our normal tradecraft for this? So, AD Hatch. Fuck, okay. Hatch was the senior guy in. He was the senior guy in. Was he the SBO? Okay, we're on page 23. Hi, Admiral. What's up? Researching something? We're reading this order on. We're reading this order on Trump's targeting of pro-Palestinian protests for deportation. Fuck, we need a background thing, I think. Too confusing. So the DHS secretary is Christy Noam. Fuck, that's CBO Armstrong. It says Rudio up here, doesn't it? What if they support the Proud Boys of the Wagner Group? That's based. There it is. There's Watson. This motherfucker. Andre Watson. Oh, this is AD Hatch. Assistant Director AD Hatch. Wait, Assistant Director of what? Assistant Director is the... So, Intelligence, Peter Hatch. Just watched the racism video. I had a couple of racism videos. Assistant Director A.D. Assistant Director Peter Hatch. Okay. What page were we on? Like 26? Yes, okay. Instructed by A.D. Hatch. Page 23. I would be curious if qualified black people are underrepresented in CEOs. I would think so. Notably, no direction or definition as to what supporting terrorist organization was provided. A.D. Hatch stated, however, that his office performed their analysis in the usual manner. Does not make judgment on whether activity actually supports or doesn't support terrorism, so we look for activities such as support for terrorist statements in support of a terrorist leader, everything from that material support, which would be providing money to terrorist organizations or making donations to organizations that's affiliated with a terrorist organization, but I really don't want to say more detail than that. Hey, Hex. A.D. Hatch was told by the DHS leadership to review the names of student protesters on the Canary Mission website, which contains a database of over 5,000 individuals. Canary Mission's website purports to document individuals and organizations that promote hatred of the USA, Israel, and Jews on North America college campus and beyond. Our mission was unaware of the website. Within a week of the early... this is the ruling from that one judge on Trump's violations of the First Amendment in regard to deporting pro-Palestinian protesters. So-called Tiger Team was assembled to expedite the preparation of ROAs. Hatch confirmed that the Tiger Team's process was that the Office of Intelligence would find fact, National Security Division of Homeland Security investigations would compile the information and provide it to the State Department. State Department would decide what action to take. The use of the Tiger Team is not a pejorative, as a common internal practice of referring to the speed and intensity of the work to be completed. The phrase is not intended to intimidate or, indeed, to be publicly known. Okay. Due to the workload, the requirement to review all 5,000 individuals on Canary Mission's website, the assembly of the Tiger Team required analysts to be taken off of counterintelligence units, the counterterrorism intelligence units, from cyber intelligence unit, from the global trade intelligence unit, from all different parts of HHSI intelligence. What a way to fight terrorism. This is page 24. Trump is the GOAT. Yeah, it really seems like it due to the way that this is going. Canary's missions list made up the bulk of the sources for HSI's investigations. There were others, for example, Hatch also related that the teams relied on Bader's US's website for additional names. He was also provided lists of names from HSI top leadership. Some of those leads apparently came from Tom Homan. Review of protest activity was new for Hatch, who had been in this position since 2019 and had not been requested to undertake such activity prior to 2025. Hatch understood that his department's ROAs were to focus only on those engaged in protest because of the volume of the names on the list, which was a deviation from their normal practice of doing ROAs on all that were reviewed. Thus, of approximately 5,000 individuals investigated by the Office of Investigations, ROAs were prepared for less than 5. Less than 5%. Due to oopsies. Wrong place. Removing people off the counterterrorism units to harass random harmless college students is nuts. True. Public officials pursue student protesters using elastic definition of anti-Semitism. Ideally. On March 3rd, 2025, the Joint Task Force, including the Department of Health and Human Services, Department of Education, General Service Administration, announced a comprehensive review of higher education contracts and grants for, I don't even know what that word is, dereliction of duties. I do know that word. To curb or combat anti-Semitism, violence, and harassment. Is quoted saying, anti-Semitism, like racism, is a spiritual and morally malady that sickens societies and kills with lethalities comparable to the history's most deadly plagues. Further, he states, in recent years, censorship and false narratives of woke cancel culture have transformed our universities into greenhouses for this deadly and virulent pestilence. March 4th, 2025, President posts, all federal funding will stop from for any college, school, or university that allows illegal protests. Agitators will be imprisoned or permanently sent back to the country from which they came. March 6th, Rubio also posts, those who support designated terrorist organizations, including Hamas, threaten our national security. The United States has a zero-tolerance policy for foreign visitors who support terrorists. Visitors of U.S. law, including international students, will face visa denials or revocations. Trust me, Dilly. I do see you. I really do. I promise you I see you. Alright, I guess we're taking a Dilly break. Look at this baby. Look at this baby. She won't leave me alone. Oh, I'm sorry, Dilly. She won't leave me alone. She will not leave me alone. She's learning her lesson right now for not leaving me alone, because I know she fucking hates this. I know she hates it so much. Don't you, Dilly? You're gonna jump down, aren't you? Can you jump down here so you don't turn my computer off? Or just don't jump down? Okay, thank you. March 6th, 2025, HSI issued an ROA for Chung, a legal permanent resident, LPR. According to the report, Chung's criminal history included charges for obstruction of government administration, disorderly conduct, and trespass relating to demonstration. That evening, Watson signed but did not compose a referral letter at the State Department. The purpose of the letter was to provide a summary of the actions by Chung that violate President Trump's executive order on anti-Semitism. Billy, you really fucked me up, girl. Watson stated that Chung's LPR status and related that Chung's involvement in the March 5th, 2025 protest, whereas Hamas flyers were distributed, aligns with the executive order on deporting Hamas sympathizers. He further stated that social media posts indicate that she was a figure in the library occupation where protesters distributed Hamas-authored flyers. Buddy, if you want to, please, I encourage you to keep chatting in chat, but I also encourage you, because I figure you're probably too scared to. But I have a Discord server, all right? If you want to come up and debate, because I am a debate live streamer, okay? I do that first and foremost. We can pause the reading if you really want to. You can come up and debate, all right? I have a Discord. We can have a chat if you really want to. I was gonna do a chill stream, but we have illegal agitators in the chat. I can't stand by that. I can't stand by that. Okay. Hey, I'll be garbage. Hey. Okay. LOL. Okay. Though there was neither an allegation nor evidence of Chung distributing flyers herself, Watson asserted that HSI is concerned with the distribution of Hamas-authored flyers. Hi, Pornhub. Good to see you. Can I debate you? Yeah. Server's open. If you want to come in and debate, we can come in and debate. Although I'm a little suspicious of your thing, but Lady Watson concluded that by requesting the Secretary of State determine whether there are compelling adverse foreign policy consequences for the United States from Chung's presence or activities consistent with the INA, and stated that if it did make that determination, HSI would initiate removal charges against Chung. Apparently attached a copy of the ROA. March 6, 2025, HSI issued an ROA for Mahmoud Khalil, an LPR, and spouse of United States citizen. Khalil, ROA. No criminal history was noted in the report. According to the report... Oh, okay, you're like a white nationalist guy. Okay. March 6th, HSI issued an ROA for Mahmoud Khalil. No criminal history was ever noted in the report. According to the report, attached news articles and social media posts indicated that Khalil had been critical of Israel and participated in demonstrations at Columbia University, including an article from Canary Mission characterizing him as having participated in pro-Hamas encampment at Columbia in April 2024, and a lead negotiator on behalf of Columbia University Apartheid Divest, an anti-Israel student coalition. March 7th, A.D. Watson signed but did not compose a referral letter to DFO Whiting. That letter, similar to Chung DHS letter, was intended to provide a summary of actions taken by Mahmoud Khalil that violate Trump's presidential order. Confirmed his LPR status and related that Khalil's involvement with March 6th were distributed aligns with the order's focus. Further stated that his leadership and disruptive protests create a hostile environment for Jewish students, and that Khalil identified as a prominent pro-Palestinian activist in anti-Semitic activities. What is it? What's it called? DHS referral letter. A.D. Watson continued, stating that social media posts and news articles attached to the ROA document his leadership roles, including the occupation of Columbia University's Hamilton Hall. Further than recent social media posts in March 6, 2025 indicate Khalil was a key figure in Barnard College library occupation, where protesters distributed these flyers. Again, though, there is neither an allegation nor evidence that Khalil actually distributing these files. Though, as set forth below, public officials allege this anyway. A.D. Watson asserted that the HSI is concerned that the distribution of Hamas-authored flyers, leadership role in anti-Semitic activities, and leadership in disruptive protests may undermine the U.S. Foreign policy goals of protecting students. That's not how TTS works, I don't think. Okay. Authored an action memo for the secretary as to both Chung and Khalil. The recommendations: Armstrong recommended Secretary Rubio determine the presence of activities of Khalil have potentially serious adverse policy. Armstrong relied solely on the DHS referral letter. Notably, Armstrong never received guidance on what constitutes anti-Semitism. Rather, he believes that there's a common understanding in our culture and our society as to what anti-Semitism is. Armstrong elaborated as to what he viewed as anti-Semitism as definitionally the absence of guidance. I'd like to ask now, what would you state that, so I understand it, what you think the common understanding of what anti-Semitism is? Anti-Semitism is the unjustified views, biases, or prejudices of or actions against Jewish people or Israel. Bias against Israel? Really? Okay. In other words, your understanding anti-Semitism includes hatred or prejudice against Israel and the Israeli people. Anti-Semitism will try to hide their views and say they're not against Jews, they're just against Israel, which is a farcical argument in my mind. It's just a dodge. Okay. Armstrong is informed by the public statements of Secretary Rubio that the United States has a strong policy against anti-Semitism, particularly on college campuses. According to Armstrong, this includes anyone organizing anti-Semitic criticism of Israel similar cannot be regarded as anti-Semitic. The activities Chung and Khalil in the United States have potentially serious adverse policies because of their participation in roles in anti-Semitic protests, disruptive. DHS has not identified any alternative grounds of removability that would be applicable to Chung and Khalil, including grounds of removability for aliens who have provide. Oh shit. The activities of Khalil and the United States have potentially serious adverse foreign policy consequences and would compromise a compelling U.S. foreign interest because their participation and roles in anti-Semitic protests, disruptive for activities, hostile. Additional measures. It is policy for the U.S. to combat anti-Semitism using all available legal tools to hold accountable perpetrators of unlawful anti-Semitic harassment and violence against Chung and Khalil. To remain in the United States undermines U.S. policy. To Rubio, he concluded that United States. He goes on to say in a different memo. DHS has not identified any alternative grounds of removability that would be applicable to Chung and Khalil, including grounds of removability for aliens who have provided material support to a foreign terrorist organization or terrorist activity. We are not aware of any prior exercises of the Secretary's removal authority under the INA, and given their LPR status, Chung and Khalil are likely to challenge their removal under this authority and courts may scrutinize the basis for these determinations. That's pretty crazy. When questioned about prior usages of the INA, Armstrong clarified that he believed the INA was used at other times. So this means that the argument about providing material support to terrorists in regard to Mahmoud Khalil was complete bullshit. The DHS already agreed with that. That's bad. Secretary Rubio adopted Armstrong's recommendations. March 8th, 2025. In the memorandum, Rubio explains that he has exercised his authority to classify Mahmoud Khalil and Chung as deportable. He then explained the reasoning. Administrative Form I-200, arrest warrant for Khalil. Khalil was arrested in the lobby of his apartment building in New York City in the early evening of March 8th, 2025. before HSI officers participated, they identified themselves with neck badges visible. The agents did not wear masks, though again, there was no mask policy. HSI special agent in charge of Khalil's arrest was informed that the Secretary of State and or the White House had an interest in Khalil. July 15th, because HSI agents have not in recent history enforced the INA, he contracted ERO to confirm that there was a legal basis for the arrest. As for Chung, she obtained a temporary restraining order prior to the arrest. There's a preliminary injunction in place. The officials publicized the arrest of Khalil and the speech of plaintiffs. Rubio posts on social media, we will be revoking so they can be deported. Yep. She learned of Khalil's arrest. She became afraid and being harassed upon re-entry into the United States and possibly deported. She canceled overseas trips. Shied away from writing on certain topics critical of Israeli policies. If the alleged ideological deportation policy were ended, testified she would resume activities as research, travel to the Middle East. Okay. This is just talking about people that they chilled the speech of, I think. Okay, this person probably is anti-Semitic. Married to U.S. citizen, daughter of Ahmed Youssef, a senior Hamas figure. Okay. Khalil sided with terrorists. Okay, you are here as a visitor. We can deny the visa. We can deny you that if you tell us you apply. Hi, I'm trying to get into the United States on a student visa. I'm a big supporter of Hamas, a murderous, barbaric group that kidnaps children, that rapes teenage girls, that takes hostages, that allows them to die in captivity, that returns more bodies than live hostages. If you tell us you are in favor of a group like this, and you tell us when you apply for your visa, and by the way, I intend to come into your country and rile up all kinds of anti-Jewish student, anti-Semitic activities. I intend to shut down your universities. This is not about free speech. This is about people who don't have a right to be in the United States to begin with. Okay. Says he acted as a spokesperson. Okay. Okay. Okay, I think we're just gonna get to the conclusion of this now. I feel like we got a lot of... Oh, fuck. Never mind. Ozturk. Okay. March 21st, 2025, A.D. Watson signed but did not compose a referral letter of CBO. Okay, wait, hold on. Okay. March 17th, 2025, HSI issued an ROA on Romeo Ozturk. Tufts University graduate student on a student visa. According to the report, I'm going to cite this here. Bakers, get the fuck out of me. Hello. HSI located no criminal history or HSI investigations associated with Ozturk. The ROA attached articles, including an article co-authored by Ozturk, op-ed, Try Again. The op-ed took the position from Tufts University that Tufts University should divest from Israel because of credible accusations against Israel, including the deliberate starvation and indiscriminate slaughter of Palestinian civilians. Attached to the ROA was a news article from Boston.com showing the suspension of a group of the group Tufts University Justice for Palestine in Palestine. Saying this article ties the op-ed and ties into the op-ed and demonstrates that the tough SJP was suspended by the university for violations of having signs demonstrating weapons and calls for a student intifada, but that the analysts were unable to locate images matching the exact reference to the signs. Nothing in that article is attributed to Ozturk. Holy fuck. Described F1 visa status. He then identified Ozturk as the author of the op-ed. Watson then connected this to the graduate students' call for the Intifada. Although there's no direct connection alleged between these groups. Dude, the justification for the deportation of Ozturk is like fucking insane, dude. What the fuck? Although the logic is somewhat hard to follow, Watson concluded that Ozturk's co-authoring of the op-ed that the authors joined in voicing opposition to Tufts' investment in Israel with a different group that later was suspended for alleged violent imagery and call for intifada somehow was an association that may be used to Jesus Christ. Jesus. Later that day, Secretary Stuart Wilson determined that the latter course of action was an appropriate way to proceed. Jesus. Wait, hold on. Proceed. Recommending a silent revocation and a notification to the Department of Homeland Security of the revocation of her visa. All right, give me 1 second. I have to let my cat out. D.A.S. Wilson's memorandum recounts that Ozturk co-authored a Ozturk has been involved with action protesting Israel. DHS has not, however, provided any evidence showing that Ozturk was engaged in any anti-Semitic activity or made public statements indicating support for a terrorist organization or anti-Semitism generally. While Ozturk implies a connection between, while the Ozturk ROA implies a connection between Ozturk and now banned Tufts student for justice in Palestine, the report presents no evidence other than Ozturk's membership in Graduate Students for Palestine, which supported proposals to the Tufts, which were also supported by TJSP. Nor has DHS, ICE, HSI shown any evidence that Ozturk was involved in any of the activities which resulted in TSPI being banned. Jesus Christ. In summary, Wilson concluded, although information provided does not establish potential ineligibility for Ozturk, you may, in your discretion and in accordance with department policy, approve the revocation of her visa immediately, based on the totality of the circumstances. Holy fuck, dude. This is like, this is disgusting. When presented with the question by the court of whether engaging in student protest, nonviolent standing alone, is consistent with the student visa application, I'll state it differently as grounds for revoking visa status. Smith answered, I think it's a difficult question to answer. If it's nonviolent protest and it's not a protest that is supporting terrorism, then I'm not sure what would be the problem. I think we would probably see it in a negative light if the person were protesting in a way that supports terrorism, even if it's nonviolent. SBO Armstrong wrote, among other things, actions, not words, in his notes, testifying that he viewed it as totally different circumstances. In her particular promoted connection with a band... Okay. The court, as you looked at this paragraph and evaluated it in the totality of circumstances, is it correct that you considered or were considering at least two actions? I'll name them. One is the writing of the op-ed, and the second is affiliation with the group that sponsored the op-ed, which had your inferring from this a connection to the now banned student group. Have I got that right? Okay. In reviewing it, the key thing is looking, and as I recall, based on my notes, the key thing made was the key in my decision were her actions. The one, actions of protesting Tufts' relationship with Israel. Secondly, her activities and association, which are not speech, activities and associations with groups that may undermine foreign policy and creating a hostile environment. To be sure, indeed, looking at the totality of circumstances, nevertheless, there is no evidence that Ozturk did anything but co-author an op-ed that criticized the university's policy on investments with Israel, that she criticized Israel, and that organizations of which she was a member joined in that criticism with an organization that was banned on Tufts University in which she was not affiliated. Page 70. March 25th, yeah, Ozturk was arrested by HSI agents at 1:51 of the Ozturk arrest video, 3 plainclothed officers exit a gray SUV, none initially wearing masks and waiting to appear. At 2:21, 2 plainclothes federal officers appear to identify and approach Ozturk. Again, neither are masked, but the closest is wearing a baseball cap and a hooded jacket. As that agent approaches and converses with her, he grabs her hands. Ozturk appeared confused, pulled away, and screamed. Closest of the unmasked agents appeared to pull out his badge and lanyard to show it to Ozturk. Other agents almost appeared immediately. To all the federal agents' credit, as menacing as their approach initially may have appeared to Ozturk, they acted properly. Okay. The agents then all masked up, with the exception of one agent who had already had a hood covering his head. Ozturk did not resist. Her wrists were cuffed to the behind her back and taking her arms. The agents had led her to a car which sped away out of Massachusetts. HSI personnel testified with respect to the masked agents. Had no policy on masks. Okay. ICE assistant special agent in charge had never seen that type of direction from the State Department and HSI headquarters, and while he assumed the direction to be sufficient because it was coming from the top, the agent consulted with a lawyer from ICE's Office of Principal Legal Advisor. Okay, we're gonna read the conclusion and then I think we're gonna go live. Because this is fucking nutty. Standing. Why did he cite holder? It's not that. This court appreciates, as the plaintiffs have urged, that several counts to have addressed the issue of non-citizen speech in recent months have stated in no uncertain terms that non-citizens' free speech rights are identical to those of citizens. Although the court broadly agrees with these analyses, the public officials are not wrong to suggest that the matter is complex. Unlike with citizens, the question involves a collision between two doctrines that do not admit easy compromise: planetary power doctrine in the immigration context and this nation's steadfast fundamental commitment to freedom of speech. First Amendment rights were implicated but emphasized longstanding principle. Congress has plenary power to make policies and rules for exclusion of aliens. Judicial review of the executive branch. Decision making with respect to non-citizens is importantly limited to certain contexts, even where recognized rights may have been implicated. Fuck, Trump v. Hawaii must have been like a huge ruling. Need to read up on that at some point. Where's the conclusion? Conclusion. Okay. For all these reasons, the court finds as fact and concludes as a matter of law, Secretaries Noem and Rubio and their several agencies and subordinates acted in concert to misuse their sweeping powers of their respective offices to target non-citizen pro-Palestinians for deportation primarily on account of their First Amendment protected political speech. They did so in order to strike fear into similarly situated non-citizen pro-Palestinian individuals, proactively and effectively curbing lawful pro-Palestinian speech and intentionally denying such individuals the freedom of speech that is their right. Moreover, the effect of these targeted deportation proceedings continues unconstitutionally to chill freedom of speech to this day. The court's finding and ruling above resolves phase one of these proceedings. The wrong suffered by these plaintiffs is amply established. What now? It is not enough for the court to simply determine that the plaintiff's First Amendment constitutional rights have been violated. The Constitution is not self-effectuating. There must be some prospect of effective remedy, what we call redressability, in order to proceed. Otherwise, this court ought terminate these proceedings at the point, lest make it become no more than a divisive scold. When this court denied the motion to dismiss herein, it thought an effective remedy might be obtainable. Today, it is not so sure. Oh boy. The reason is rapidly changing nature of the executive branch under Article 2 in our Constitution. While he is properly now not a defendant in these proceedings, the nature of our president himself. It is appropriate, therefore, briefly to address each of the concerns, then limn the constraints that properly govern remedy in these proceedings. In other court proceedings involving the Trump administration, this court has already set forth its understanding of what may be called the unitary presidency, and I repeat it here. We've never had a president like President Trump. He's the first president in our history to espouse a concept of the unified presidency, the idea that the president of the United States, and certainly he's duly elected after a full and fair election, President of the United States, he is a single superior executive motion force for all federal employees under Article 2. There's issues about whether that actually works out with the Federal Reserve and the like, but none of it's before this court, and I make no comment on it, nor do I make a comment on the wisdom of this approach. It's not for me. But it's fair to say that that's his view, or it appears to me to be his view. Now, though he's not been in office for all that long, a couple things are evident here. One is that the approach to invocation is entirely different. We're not looking to various cabinet secretaries, agencies, divisions, departments to invocate and create new ways to serve the public. I'm not saying there's no invocation. But it's all got to go through, or appear to go through, or emanate from the president himself. That's one thing. The second thing is that this president expresses his view, and he's certainly transparent. He expresses the view that through his directives, some requirements. So the idea of reasoned discourse in the sense of Lincoln's team of rivals, or FDR combating the Depression, mobilizing for World War II and creating these bureaucratic empires that sparred with one another under his final decision, that's absent from our discourse today. I ask you, we're not seeing wonky white papers out of this administration. He seems to be winning. He ignores everything and keeps bullying ahead. Half admiring, half quizzical, a very wise woman, my wife, made this comment about our 47th president in an entirely different context. I quote it here because it so perfectly captures the public persona of President Trump. Especially, it pertains to the issues presented in this case. A brief explanation will suffice. He seems to be winning, is the very essence of the Trump brand. Often, this is not but hollow bragging. My perfect administration, wearing a red baseball cap of the presidential Oval Office, emblazoned Trump was right about everything. This is indubitably true. The Constitution, our civil laws, regulations, mores, customs, practices, courtesies, all of it, the president simply ignores it when he has to take it all into his head to act. A broad swath of our people find this refreshing when they hear in what they may feel is an over-regulated society. After all, lawyers seem to have a penchant for telling you what you can't do. Trump simply ignores them. What is this citation? Let's be honest. After all, who does not want to feel the urge to stride? Let's... Okay. This is not to suggest that he is entirely lawless. He's not. An experienced litigator, he has learned, at least on the civil side of our courts, neither our Constitution nor our laws themselves, and he can do most anything until a aggrieved person or entity will stand up and say nay, take him to court. Now that he is our duly elected president after a full and fair election, he not only enjoys broad criminal immunity, broad immunity from personal liability, he is prepared to deploy all resources of the nation against obstruction. A daunting prospect, isn't it? Small wonder that our bastions of independent, non-biased free speech, those entities we once thought unassailable, have proven all too often to have only Quaker guns. Behold President Trump's successes in limiting free speech. Law firms cower, institutional leaders in higher education meekly appease President Trump. Media outlets from huge conglomerates to small niche magazines mind the bottom line rather than ethics of journalism. Whether it's social media, print, or television, President Trump is the master of communicator of the time. His speech dominates today's American idiom. Indeed, it may be said to define it. It is triumphal, transactional, imperative, bellicose, and coarse. Okay. It seems to persuade, not through marshaling data-driven evidence, science, or moral persuasion, but through power. While the president naturally seeks warm, cheering, gladsome, welcoming acceptance of his views in the real world, he'll settle for sullen silence and obedience. What he will not countenance. Oh my god, this is so fucking stupidly verbose. I fucking hate judges. He recognizes that, of course, that there are legislative and judicial branches to our government, co-equal to even a unitary presidency. He meets dissent from his orders in those other two branches by demonizing and disparaging speakers, sometimes descending to personal vitriol. Dissent is everywhere. Okay, where are we here? President, It is soundly reasoned decisions which today constitute a major bulwark of our right to free speech. It is upon these decisions this court relies in framing hereby remedy herein. For there must be a remedy. In light of all considerations just discussed, it will not do simply to order the public officials to cease and desist in the future. The harm here and the deprivation suffered runs far deeper. Following constraints will, however, govern the court's remedy hearing. Though there is no scholarship that urges otherwise, there can be no constraint of any sort on the speech of the President of the United States, be that speech statesmanlike, magnanimous, unifying, or foolish or knavish, as the President has absolute and undoubted right to speak. This court no ordered by this court shall materially interfere with public properly. They're having a hearing on remedy, I guess. Okay. We'll read about the Portland stuff in a little bit, I guess.